Mr. Chairman, members of the committee, my name is Michael Farris. I am honored to be here today, and thank you so much for the opportunity to testify. Just a quick note of clarification as I begin. The House vote that took place last week was on the term limits resolution, which is slightly different than the one that we're proposing. So I would like to begin by just giving you a little history of Article 5, but even before that, I'd just like to preface it with a little bit of my background. I'm one of the few lawyers in the country who's actually litigated an Article 5 case. When the Equal Rights Amendment was originally proposed, it was given 7 years for ratification. Congress purported to change that by a simple majority vote about 6.5 years into that process. And shortly after that vote was taken, I represented 4 Washington state legislators who filed the original challenge to the constitutionality of the extension of time on the ERA. My case was consolidated with a case that was filed a couple weeks later by legislators in the states of Idaho and Arizona. And we litigated together, and the federal district court ruled that the process of changing the rules of the ratification process was unconstitutional. Once the rules are made, you stick by the rules. It was the basic holding of that. The case timed out then. It was accepted by the Supreme Court of the United States, but it was never argued because the second deadline passed and 38 states did not ratify within that time period. So the case was vacated as moot, but the record is you can't change the rules in the middle of the process. I also have taught constitutional law for 17 years at Patrick Henry College and have litigated, I've argued 2 cases in the Supreme Court of the United States and in the courts, the appellate courts of 13 states and 8 of the federal circuit courts of appeal. So I've been an appellate constitutional litigator for most of the 45 plus years I've been a lawyer. Why we have Article 5 in the fashion that it is came from a motion that George Mason made in the final week of the Constitutional Convention in 1787. The proposal on the table at that point in time was all amendments had to be proposed by Congress and all had to be ratified by the states. Mason stood up and said, and I'm going to paraphrase obviously, look at guys, someday the federal government is going to abuse its power, and when that happens, Congress will never propose an amendment to limit its own power. And so we've got to give the states an ability to start the amendment process. And so the record of the convention says that Mason's motion to make that amendment was agreed to nem con, which means without debate, no dissent. And so everyone saw the self-evident truth of what he was saying, that we need to have an opportunity for the states to run rather to protect the powers of the people and the powers of the states against federal abuse and federal overreach. And so my wife and I have 10 kids, and so I know something about raising kids. And it's like you have a kid and you never discipline until they're 18 or 19 or 20 years old. You got a mess on your hands. Well, we've never used the power of the states to discipline the federal government in 200 plus years. And we've got a mess on our hands as a consequence of that. The states have, state legislatures have the unique authority, the lawful authority directly from Article 5. You do not derive your authority to act in this from the Kansas Constitution or the Kansas laws. You derive it straight from Article 5 of the United States Constitution. And with that authority comes the moral responsibility, I suggest, to use it. And so the question really before us is the federal government out of control or not? And I would submit that it is. The debt alone is a great example of how it's out of control. There are many other examples, and I'm going to give 2 examples here in just a minute in particular to explain what could be accomplished by this process. But just one quick explanation of the process itself. 34 states, that's 2/3 of the states, have to vote to approve a convention for a particular purpose. There are hundreds and hundreds of resolutions out there that are still in effect and on the books, but we've never got to 34 on the same subject. And so we're well over 34 if you could just have anything would count. It doesn't work that way. You have to be on the same subject. And so the 19 states have enacted the resolution that's before you now verbatim in the operative section. not the resolving clauses, the whereases and so on. That changes from state to state. That's fine. But in the actual language, it's been done exactly the same every state. And the reason for that is so there's no argument about aggregation. If you have it exactly the same in every state, then it clearly aggregates. When 34 states do that, there must be a convention. Congress is given a role, but it's a ministerial role. They have no discretion in the process. They must call a convention. So then at the convention, it's one state, one vote. There's some people that like to say, well, where does it say that? And the record of every intrastate gathering in the United States history is one state, one vote. It's happened in multiple conventions of various kinds over the years, not an Article 5 convention to be sure, but various conventions. But even more common examples, Kansas is a party to 40 state compacts. And every state compact has either exclusively one state, one vote. That's the vast majority. Some states, some compacts have, like the Education Commission of the states, every state has an equal number of representatives, and so they vote as individuals, but you start off on the basis of state equality. It's only the interstate lottery compact that has a slight variance on the theme. There has to be two votes. It's basically a bicameral process there, and it's one state, one vote on one vote, and the other it's proportional based on the amount of lottery sales. And so that's the only exception. So the convention of 1787 was one state, one vote. Stage 1 is 34 states, one state, one vote. The ratification process is 38 states, one state, one vote. It will be one state, one vote at the convention itself. So it takes 26 states to vote for a proposed amendment. The amendment has to be germane. Our proposal says to impose fiscal restraints on the federal government, term limits on federal officials, not limited to members of Congress. It could be bureaucrats, it could be judges, it could be anybody that's a part of the federal government. And then impose jurisdictional limits on the power of the federal government. And I'll give you a couple examples of that in just a second. I do want to address, I know that one of the witnesses on the other side testified in the House. I was remote that day, but he was in person. Talks about the nature of the 1787 convention, supposedly as a runaway. You can find a lot of opinions about that on the internet. You can read blogs, you can read Facebook comments. My comments on this are published in the Harvard Journal of Law and Public Policy. And you can find that for free on the internet, but it's a peer-reviewed law review article. And it's called Defying Conventional Wisdom. If you go to a search engine and put my last name, Farris, F-A-R-R-I-S, and the phrase Defying Conventional Wisdom, you can read the article in full for yourself if you'd like. But I'd like to just briefly summarize why there's a lot of misinformation out there, and if the testimony stays true to the House side, you'll hear misinformation in just a few minutes as well. But I'll tell you the straight story first. The myth that they were only supposed to amend the Articles of Confederation, but instead enacted a whole new document, comes from a misunderstanding of a resolution passed by Congress in the midst of calling the Article 5 Convention. The process actually began with the Annapolis Convention. They got together to talk about how to fix the commerce problems they were having. They were only authorized to talk about commerce, and they quickly discovered that they didn't have enough authority to talk about the things they really needed to talk about. So they were so concerned with their lack of authority, they adjourned the Annapolis Convention, went back to their states. They proposed a format for the next convention, but they knew they had to get authority from their states to do it. And their request was to be authorized to, and I'm quoting, render the federal constitution adequate for the exigencies of the Union. And so Virginia was the first state to call the Philadelphia Convention of 1787 using that exact phrase. A total of 6 states enacted that exact phrase, appointed their delegates, gave them their instructions, and at that point, Congress endorsed the process. And in the process of endorsing it, they said only amend the Articles of Confederation. It's the legal equivalent of a National Pickle Week resolution today. It's their opinion. Thank you very much for your opinion, Congress. They never even sent it to the states. It was not the call. There was a very clear process. When they wanted to send something to the states, they voted on not only the body of the measure, but a transmittal letter was voted on. And there was no transmittal letter. There was no vote on a transmittal letter. There's no record of it ever being sent to the states. And when the delegates got together and debated their authority, and they did debate their authority at the Constitutional Convention, they always referred to their instructions from the states. That's who gave them their authority. With the exception of New York and Massachusetts, their instructions were, in Connecticut, it was almost exactly the same as Virginia, but the ones that really differed were New York and Massachusetts. They all said, render the federal constitution adequate for the exigencies of the Union. When the delegates of New York saw that they were going in a different direction than they had been authorized, they thought, they left. Hamilton stayed. He never voted again because the New York rules required all 3 delegates to be present. So there was no runaway whatsoever at the convention. They followed their rules explicitly. Now, there may be discussion about the ratification process. There were actually 2 documents sent by the founders from this. The first document was the Constitution. The second was a measure relative to the ratification process. They sent it to Congress. Congress unanimously approved the new ratification process and sent it not to the state conventions that approved the Constitution, but to the state legislatures. All 13 state legislatures, including Rhode Island and North Carolina, that originally either delayed or rejected the Constitution, all 13 legislatures voted to approve the new process by calling a ratification convention. Rhode Island's was the most interesting because they named all their citizens as the delegates to the convention and basically held a plebiscite and voted down the Constitution initially. But all 13 states approved the new process. So anybody that tells you that it wasn't done by the right process and it was a self-authenticating doesn't know their history. And I invite them to go read my article in the Harvard Law Review, Harvard Journal of Law and Public Policy, to be precise. Now, what can be done to fix the problems that we're facing? Take the $1.7 trillion bill that passed in December, supposedly a spending measure, all kinds of other things, or electoral college reform, all kinds of things jammed in this bill. If that was subject to the single subject rule that 41 states have in their state constitution, that would have been about 100 bills. Now, you wouldn't get enough floor time to get all 100 up, so some of them would have died by that process. And some of them would die because they would not be popular. And so the ability to pass these massive bills that nobody happens could be fixed by simply adopting a federal single subject rule that would be germane under the call that we're proposing. One other example that's pending right now. The Biden administration has proposed, along with the World Health Organization, a new treaty. And that new treaty would transfer from every state the ability to regulate the pandemics the way the states wanted to regulate it to the federal government with the oversight of the World Health Organization. I have an LLM in Public International Law from the University of London, and I can tell you as a matter of treaty law, that's exactly how it works. The treaty responsibility is required to be enforced by the federal government, not by the states. And so if you transfer jurisdiction of pandemics from the states to the federal government through a treaty process, it will be the president, not the governors, making these decisions. Worse than that, President Biden intends to ratify this through the executive agreement process. We've divided our treaties up. No other nation does this. And under international law, there's only one document. It's called a treaty. But the United States, for a long time. Okay, thank you. You could fix this problem and make every treaty be ratified by the Senate. Rather, right now, there's about 5,000 treaties that the Senate never voted on because of this end run the Supreme Court's approved. We can clarify that, eliminate all those executive agreements unless they're re-ratified by the Senate, and that's the kind of cleanup that we can do. It's impossible to pass something crazy. It's really hard to pass something good through this process. To get 38 states is really hard. Unless it's clean, pretty straightforward, it's not going to get ratified. And so anybody that thinks that we can lose the Second Amendment or the First Amendment or anything like that is simply not looking at the way it works. 38 states must ratify. The idea that we can get something crazy through that process simply is untenable. I would urge you to take your responsibility that the Constitution gives to you and call a convention so that we can restrict the abuse of power by the federal government. Thank you.